Good morning, everyone. This is Greg Ross, moderator for the Landager Barron Law Group webinar on a very interesting topic this morning presented by one of our partners, Roxana Verano. And our topic, of course, is the employer's conundrum, how to solve that with exempt employees. Just a couple of notes for you as attendees. This is meant to be interactive, meaning that you have a question box on your screens, and please go ahead and fill that in. Send us questions throughout as you think of them. Roxana will do her very best at the end of the webinar to get back to each and every one of you with an answer on that. And if we can't, then of course we will also, you could send us an email and we'll follow up with that, or I'll have the questions actually. You won't have to even send an email. So we will get answers back to you. Another thing is that you do get credit for this if you're looking for CEUs from HRCI or SHRM. We will be able to send that to you as well if you request it. Just again, send us a quick note and we'll email that back to you. With that, I'm going to turn the program over to Roxana. We're going to begin now and look forward to hearing and seeing your questions. Thank you.
Good morning, everybody. This is Roxana Verano, and today we are going to discuss exempt employees. I know that last month or a couple of months ago, we did a presentation on non-exempt employees, meaning hourly employees. And as a result of that, we got some questions about exempt employees, which are the salary employees. So we're going to discuss them today and see how to comply with the various provisions of the labor code and make sure that we're in compliance. So a couple things I always like to emphasize at the beginning of any wage and hour compliance presentation is some unique issues about wage and hour claims in California. First of all, always remember that the burden is on you, the employer, to establish proper payment of wages to employees. So when we're talking about exempt employees, salary employees, that means that the burden is on the employer to establish that the employee has been properly classified as a salary employee. Key to understanding the different provisions for a salary employee is having a good understanding of your wage order. Okay, every employer has wage orders that they need to comply by. Comply with, and they usually are based on industry or occupation. If you do not know what wage order applies to you, that should be on top of your list of priorities to make sure that you understand which wage order you have to comply with. Something that very often employers forget is that you are supposed to post a copy of your wage order so your employees have access to them. I always say this in all my presentations, the only way to avoid being in litigation when it comes to wage and hour is 100% strict compliance. Sometimes I say 150%, just to make it very clear that 100% compliance is the only way that you can avoid finding yourself in litigation. Something that always comes in very handy that I highly recommend to all my clients is to have a system where you conduct regular audits of your payroll records, both for your hourly and for your salary employees. You can do self-audits on some regular basis, maybe every quarter, every month, every 2 weeks. And of course, if you have not done any self-audits for some period of time, you may consider having a professional legal audit of your payroll records. The key to avoid finding yourself in litigation is to avoid technical violations. That's why I say that 100% compliance is so important. That means that we need to make sure that we are complying with all the provisions of the labor code. If we find ourselves with technical violations, that means that the employer will be subject to both statutory and civil penalties. The labor code is full of penalties that are to be issued either to the employee or to the state for violations of the code. So that means that if we are not in compliance, the employer can be subjected to significant liability, either under the provisions of the labor code, a class action, or a PAGA action, which is similar to a class action, but slightly different. Some issues that I have noticed with some of our clients is that very often they retain the services of a payroll vendor, which is perfectly fine. I actually recommend that for many of our clients because it takes that away from you having to properly calculate the payment of wages. However, having said that, do not rely on your payroll vendor for compliance with the law. Their job is not to make sure that you're in compliance. Their job is just to process whatever information you have provided them. So make sure that you do your own audits and that you are in compliance. I've had many clients who maybe have an agreement with a payroll company where the payroll company agrees to maintain record keeping for them for 2 years. Well, under California, we need to have them at least for 4 years. And so the payroll vendor is relying or assuming that the employer will maintain copies of those documents. So it's just little things like that. Or very often a payroll vendor will pay employees on a salary basis when maybe they're supposed to be hourly, and they say, well, we do what the client tells us to do. They told us to pay a flat amount, so we did. So the point is that it's up to you, the employer, to ensure that you are complying with the provisions of the labor code and that your employees are properly classified. It's not the responsibility of the payroll company. The reason why we see so much activity in this area of wage and hour is that these provisions of the labor code provide for the employee to recover his or her attorney fees when they file a claim against the employer. So that makes these cases very difficult to defend, and then make it very appealing to plaintiffs' attorneys because they know that if they recover $1 from the employer, they also will be able to recover all their attorney fees. So that's the reason why we see so much litigation in this area of the law. Unfortunately, it does not work the other way around. If an employer prevails in a labor code violation claim, the employer cannot recover its attorney fees. Only the employee can, except for rare circumstances. Okay, so proper classification. The default for employees is to be an hourly employee, meaning a non-exempt. So in order to classify an employee as an exempt employee, as a salary employee, we have to make sure that they meet the strict criteria that is found in the wage orders in the labor code. Now, why do we call these exemptions? We call them exemptions because if an employee can properly be classified under one of these exemptions, then the employer is relieved from the obligation of paying overtime, the obligation to provide meal and rest periods, the obligation to track hours, and all those other obligations that come along with having an hourly employee. So employers like having salary employees. They like having exempt employees. But however, like I said a few seconds ago, it's very difficult to meet those requirements. So we have to make sure that if we're going to classify somebody as an exempt employee, which means that we don't have to worry about paying overtime, we don't have to worry about meal and rest periods, we don't have to track hours, we don't have to maintain records and all these other requirements, we have to make sure that they have properly been classified, or otherwise you'll be subjected to significant liability. So there's 3 major exemptions under these provisions. One of them is the executive exemption, the administrative exemption, and the professional exemption. In addition to those 3 major ones, there's also an outside salesperson exemption, the computer professional exemption, and there's some healthcare professionals that are also exempted under very narrow circumstances. Now, all these exemptions have 2 tests. One of them is what we call the duties test, and the other one is the salary test. Both tests must be met in order for an employee to be properly classified as a salary employee. And we're going to go through these tests during this presentation. Okay, so the duties test, let's start with that one. The law doesn't really care much about the title of the employee or the job description of the employee. The law will concentrate and will analyze the actual duties being performed by the employee to determine whether or not the employee has met their requirements. Okay? So the job description is helpful, and I highly recommend that every employer who has a salary employee that they have a job description for the position. It's very, very important. Now, it's helpful, but it's not going to be the only factor that's going to be looked at by the law when determining whether or not a person has been properly classified, okay? So the test is that that employee must be primarily engaged in duties that are of an exempt nature. That means that they have to spend more than 50% of their time performing those duties that are of an exempt nature. What do I mean by that? Generally, when we have a job description, there's going to be a long list of duties. Some of them might be of an exempt nature and some of them may not, and that is okay. But the employee must perform duties of an exempt nature more than half the time that they're working. Okay. Maybe an easier way to explain this is think of a manager at a Starbucks location. Their managers, maybe they're supervising employees, they're setting schedules, and those type of duties that are of an exempt nature. But generally, the managers at Starbucks are also making coffee and taking care of clients. The key there is that that employee must be performing those exempt type duties more than the non-exempt, like answering the phone or taking care of clients that come into the store. Okay, so the employee is primarily engaged in managing the business. Okay, so let's start with the first exemption. I was going ahead of myself here. The executive exemption. This was kind of easy to understand. This is when the employee is primarily engaged in managing the business or managing a recognized department or subdivision of the business. So this is somebody who's truly engaged in the management of operations of a business. Now, in addition to that, the executive exemption also requires that the employee customarily and regularly directs the work of 2 or more other employees. So they need to be supervising employees. In addition to that, that employee must have the authority to hire or fire, or at the very least, be able to recommend the hiring, firing, or promotion of employees. And in addition to that, we go back to the salary test, which they have to earn at least twice the minimum wage. And we'll talk a little bit more about the salary test later in the presentation. So as you can see, the executive exemption is pretty simple. That person needs to be engaged in the actual management of a business or a recognized department of the business. Then we have the administrative exemption. This was a little more gray in this exemption. So under this exemption, the employee is primarily engaged in the performance of office or non-manual work. Okay, so this is the office scenario, directly related to the management policies or general business operations of the employer or the employer's customer. In addition to that, the employee must customarily and regularly exercise discretion and independent judgment. And this is the key. Not only do they have to be working in an office, but they also have to exercise discretion and independent judgment. If the duties that this employee performs does not require the person to use discretion and independent judgment, then they're not going to meet the requirements of the administrative exemption. The person also must regularly and directly assist an owner or perform only under general supervision. This goes back to the independent judgment factor. And of course, they have to earn at least twice the minimum wage, which is the salary test. Now, the professional exemption, we have 2 subsections here. So one of them is a licensed or certified employee, a licensed or certified by the state employee that primarily engages in law, medicine, dentistry, optometry, architecture, engineering, teaching, or accounting. So you can see this is very black and white. It has to be either a lawyer, a doctor, a dentist, an optometrist, architect, engineering, teacher, or an accountant. And they have to be licensed or certified by the state of California. Remember something to keep in mind. Having the professional education alone is not sufficient. If you have an engineer who's licensed, but is just doing clerical office-related engineering work and is not really doing the duties of an engineer, then that person is not going to be exempt under this exemption. Now, the employee must be primarily engaged in an occupation commonly recognized as a learned or artistic profession. That is the second subsection under the professional exemption. Now, both of these individuals must customarily and regularly exercise discretion and independent judgment. That's the key. You're going to see this requirement across the board on all these exemptions. They need to exercise discretion and independent judgment. And again, they must earn twice the minimum wage. So we're going to talk a little bit more about doctors. And I do this because we do represent quite a few medical facilities. So think of two subsections where we're talking about the professional exemption. One is going to be the licensed or certified by the state professionals in law, medicine, dentistry, optometrist, architecture, engineering, teaching, or accounting. This exemption does not apply to pharmacists. Very often people believe that applies to pharmacists. It will not. Only to doctors. Now, there's another option for doctors, and I only bring this in because we do have quite a few clients who operate medical facilities. A physician can be paid by the hour, meaning that we choose not to pay that doctor under the exemption because we want to hire the doctor on an hourly basis. And the law allows us to do that under Labor Code Section 515.6. It's a very narrow provision for doctors. It does require that the doctor be licensed. The doctor needs to be primarily engaged in duties that require a medical license. And the doctor must be paid at least $82.72 an hour. Okay? This exemption does not apply to interns or residents. It also may not apply to doctors who are in a collective bargaining agreement. So there's a little exception. If we have a doctor that we do not want to hire as a salary employee, we can hire the doctor by the hour as needed. Okay, so going back to the second professional exemption under the wage orders, we have what they call the learned or artistic profession. This individual primarily is engaged in work requiring advanced knowledge in a field of science. That's going to be like a chemist. It's going to be an astronomer, those type of positions. Or learning and acquired through specialized instruction. So this is somebody who, first of all, has to have a degree. It has to be generally at least a 4-year degree or higher. And it is a very specialized field of science or learning. Or the other option is somebody who is a creative person. So their work is original or creative in a recognized field of artistic endeavor. And those two professionals must work in an area that is intellectual and varied, not something that is routine, not somebody who's just following instructions, but that actually creating something and or applying that high advanced degree that they have. So generally we have people who are writers, graphic artists, actors, musicians, and those type of professions. Now, just to give you an example of how this differs a little bit, a writer that maybe just reports the news will probably would not fall under this exemption. A columnist that actually has to write an opinion, that columnist will fall under this exemption. So these are very, very detailed requirements. And that's the reason why very often employers will have problems with these. So I highly recommend that if you're going to classify somebody as an exempt employee because they fall under the professional exemption, that you consult with legal counsel to make sure that you're meeting all these very detailed and specific requirements. And don't forget that for the professional exemption, again, they need to earn at least twice the minimum wage. Okay, that is across the board for these three major exemptions. Now, in addition to those three major exemptions, the administrative, the professional, and the executive, we have the outside salesperson exemption. This only applies when an employee spends more than half of their work time away from the employer's place of business. So this does not apply for somebody who does inside sales. Okay, think of the those in the old days, the salesperson, the salespeople that used to go door to door to sell encyclopedias. The person has to spend more than half their time outside the place of business. Generally, these employees earn commissions from sales of products, services, or use of facilities. If the employee spends more time delivering a product or services rather than selling, then the employee is not going to be an outside salesperson properly classified as an exempt employee. Okay, we're not going to get into the inside sales position, but just remember that an inside salesperson will have to be paid on an hourly basis or commissions, but cannot be a salary employee. So it truly has to be somebody who's outside of the office selling a product, services, or some other use of facilities. Then we also have a computer professional exemption. Here, the employee's compensation must either satisfy the salary basis test or be paid on an hourly basis at a rate that equals or meets the salary test. We see a lot of issues with this exemption as well because it also has very strict requirements. This applies to a person who's employed as a computer systems analyst, a programmer, a software engineer, but it has to be somebody who's really applying their computer background or knowledge in a way that they're using, again, that independent discretion, independent judgment. They're really developing programs. This would not apply to an IT person who is just maintaining systems or programs. They really have to be creating something. I think the best example of this is a computer system analyst. It's not somebody who's just applying a program, but it's somebody who's creating a program, who's analyzing information, and it really requires that higher level of either education or experience. The employee's primary duty must consist applying systems analysis procedures, consulting with users or hardware, software. This is the best part probably that describes this exemption. Designing, developing, analyzing, testing, and modifying programs related to the system, designing and operating systems. A combination of these duties, the performance of which requires the same level of skill. So think of a really highly developed computer professional if you want to apply this exemption. I can tell you that most of the issues that we see with the salary exemption are computer professionals and the outside salesperson exemptions. Those are probably the ones that we see more often where employers are not meeting the strict requirements of the law. Okay, so moving on to the exempt employee salary basis. The salary must be guaranteed with a fixed amount each paid period. Okay, this means that the salary does not change. That person is being paid in a monthly amount that doesn't change regardless of the individual's amount of work, hours of work. Think that an hourly employee gets paid for the quantity of work they perform for you. A salary employee gets paid for the quality of work that they perform for you. That means that you agree to pay that employee, let's say, $1,000 a week, whether they work 20 hours or whether they work 50 hours, okay? Because you're not paying for the quantity, you're paying for the quality, okay? So all these exemptions require that the employee be paid at least twice the minimum wage. I think we have a chart in this presentation that will give you the different rates. Remember that we have increases every year now on the minimum wage, which means that employers must reassess the salary of their exempt employees at the beginning of each year. Now, many of you might be required to comply with the local minimum wage requirements, like Los Angeles, San Diego, San Francisco, Pasadena. They have their own minimum wage requirements. However, for this test, we only need to comply with the state minimum wage requirement as far as the test. So the assumption is that the employee, a salary employee, is working about 40 hours a week. Having said that, that's the presumption. However, the employee may work less or more, and they're still required to receive the same monthly salary. When I say monthly salary, that's what how we calculate the minimum of the twice the minimum wage. But remember that you can pay the salary employee either biweekly or once a month. Generally, California law requires that you pay your employees at least twice a month. Okay. We do not consider bonuses in calculating the salary threshold. We also do not include commissions when we calculate the salary threshold. Here's the chart. As you can see now in 2019, if an employer has 26 or more employees, the minimum wage right now is $12, meaning that is the state minimum wage. If the employer has 25 or fewer employees, then the minimum wage is $11 an hour. Those numbers will go up in 2020. As you can see, they're to $13 and to $12 an hour. This is significantly higher than the federal minimum wage, which is $7.25. And as you can see, we also have there the minimum wage for LA City, which is significantly more. If the employer has 26 or more employees, they have to pay their employees $14.25 as of July 1st. And if they have 25 or less, $13.25. But remember that for the salary exemption, you only need to be concerned with the state, the California minimum wage, and it has to be twice that amount. If you are within one of those cities, LA City, you're going to see a minimum wage increase every 6 months. One from the state on January 1st and one from the city on July 1st. Okay. Okay, so if we take that minimum wage, the state minimum wage, here this chart tells us what the minimum salary is for your exempt employees. So in 2019, as of January 1st, if the employer has 25 or less employees, the minimum salary for an exempt employee is $45,760 a year. If the employer has 26 or more employees, then the minimum salary is $49,920. Now, having said all this, I have many clients that tell me, Roxana, we cannot afford to pay these twice the minimum wage to our salary employees. There's nothing that prevents you from keeping an employee as an hourly employee. In order, as an hourly employee, like I said at the beginning, the default is that employees are hourly employees. You can keep anybody as an hourly employee. You use the benefit of the salary employee if you want to be able to have a set amount that you pay them every month, and you don't need to calculate all the time how much they have to be paid, and then you don't have to worry about the overtime, meal and rest periods, and all those other requirements. But even if somebody meets the duties test of the exemptions, the administrative, the professional, and the executive, but you prefer to keep that person on an hourly basis to avoid having to pay a high salary, you can do that. But again, the downside is that now you have to keep track of the hours, you need to pay overtime, you need to keep track of the meal and rest periods. And all this chart also gives you the equivalent of the weekly amount for each one of those, for each one of those categories. Okay. One of the areas where employers get in trouble is when they classify somebody as a salary employee, but then they want to make deductions from their salary. As a general rule, deductions are not allowed from a salary employee because, again, the idea is that you pay them that set amount every month for the quality of work and not the quantity of work. Okay, so that person is going to be entitled to the same salary whether there's work, whether there's no work, whether they work 10 hours or whether they work 50 hours or 60 hours. Okay. You are allowed to deduct a salary employee's pay if the employee misses a whole work week. Okay. So let's say that somebody wants to take a vacation for a week, but they have no vacation available, or maybe the employer doesn't offer paid vacation. So they can take that week, they want to take that week, but they understand it's going to be unpaid. Okay, so in that situation, you can deduct the whole work week from their pay. Okay, salary workers' pay not subject to deductions for portion of a work week with some exceptions. Okay, so if somebody misses 2 days out of the work week, generally you're not allowed to deduct their pay. You still have to pay them for the whole work week. Let me give you an example. You have a salary employee who needs to show up for jury duty. And they're not gone for a whole week. They're only gone for 2 or 3 days, and they return to work. You cannot deduct those 2 or 3 days from the pay. You still need to pay them for the whole week. Now, you may have noticed that I do have there that phrase that says with some exceptions. That is because there are a few exceptions. They're a little bit risky, but there are some exceptions. If a salary employee takes time off that is less than a work week for personal reasons, okay, again, like maybe I don't have transportation, my car broke down and I won't be able to come in to work for 2 days, okay, then in that case, you can deduct that 1 or 2 days of pay. It cannot be done if the employee has missed less than a work week because of illness or disability, only for personal reasons. And it has to be a full day. We are not allowed to deduct for portions or partial days, meaning 4 hours or 5 hours. Okay? So just to kind of recap this, because it can get a little confusing. As a general rule, a exempt employee is entitled to his full salary pay. You can deduct from the pay only if the employee misses a full work week of work. You might be allowed to deduct for less than a work week, but only for full days and only if the employee missed the work for personal reasons, not due to illness or disability. Okay, you are allowed to require an employee to use available vacation or other time off when they miss a full day of work. You are allowed to do that. You can compel them to use their vacation. What happens if we start making deductions that are not allowed under the law? If you make deductions that are not allowed under the labor code, then you lose your exemption. The employee can claim, I really was an hourly employee that should have been paid overtime and should have been entitled to meal periods because they were deducting my pay. My pay was not a set amount every pay period. Okay. So that's the reason that we need to make sure that we are very careful with any deductions from the pay of a salary employee. So what is the consequence of that? The reason that we emphasize the fact that you could lose your salary exemption is the consequences of that. So if I'm an employee, let's say that, let's set a different example. You have a salary employee and you expected him to work 50 hours a week. And he knew that. He knew that he was going to get the twice the minimum wage as a threshold, and that he was going to work about 50 hours a week. Not 40, but 50. Okay. So if that employee later says, no, I was not properly classified as a salary employee, I really should have been an hourly employee, the state of California is going to take that salary that was promised to the employee, let's say in my scenario here, let's say $600 a week, which is actually lower than the requirement, but okay, let's say $600 a week. I think we probably chose that number just for convenience. But $600 a week and you expected him to work 50 hours. The state of California is going to take the $600 a week and divide it only by 40, because that's the presumption. That gives you a $15 an hour rate of pay, instead of the $12 that you thought you were paying him for 50 hours of work. So now the law is going to apply the $600 only to the 40 hours, the first 40 hours of work, and anything beyond the 40 hours that should have been paid at the overtime rate will be paid at the time and a half rate from 15 and not from 12. So as you can see, that can, if you have somebody who's been employed with you for 3 years or 4 years, that amount can be significant after some period of time. And that doesn't even include all the penalties that will come along if the employee was improperly classified, and then the law finds that they are owed for all their overtime that they had worked for those 3 or 4 years. Okay, so the consequences is that if you have a salary employee, that means that you generally would not have timesheets for them, so you cannot determine how many hours they actually worked. Remember that I said at the beginning, the burden is on you as the employer to show how, to show that the person was properly classified, to show that the person was properly paid. So if the employee is able to show that they were misclassified and they should have been paid as an hourly employee, now you're not going to have timesheets because you didn't keep timesheets for a salary employee, and the law is going to accept whatever they claim as the hours of numbers, as the number of hours they worked. So you're going to have an unpaid overtime liability. You also did not keep track of meal and rest periods because as a salary employee, you were exempt from that. So you could have liability for that. Also, your pay stubs under Section 226 are not going to be accurate because you didn't keep track of the hours, the number of hours the employee worked. So you'll have those type of penalties, and other penalties for not having the proper record keeping of time records for an hourly employee. And of course, Section 203 penalties, if the person no longer works for you, then they will be entitled to 30 days of pay if they were not properly paid by the time of their termination or separation of employment. As you can see, this liability can be significant when somebody gets misclassified as a salary employee. So that's why we always say, when in doubt, if you're not quite sure whether the person actually meets the requirements of the exemptions, then my recommendation is pay them as an hourly employee, not worth the risk. You should only classify employees as exempt as salary if it's crystal clear that they meet the requirements of the exemptions. And now remember that with your non-exempt employees, you must maintain accurate time when they start working and when they finish working, as well as the start and the end of the meal periods. It's critical that you are compliant with the meal and rest period policy for your hourly employees. Generally, rest periods do not have to be recorded for your hourly employees. If you're able to do that, it's a good idea, but only if you're going to be able to accurately keep track of that. Sometimes it becomes more difficult and it hurts to have only partial records of the rest periods. So I generally say make sure that the employee is clocking out and back in from lunch periods, I don't worry so much about rest periods. As long as you have the proper policy in place, that should be sufficient protection for a rest period claim. Excuse me. Okay. For both your exempt and your non-exempt employees, it's very important that you comply with all the requirements of Section 226 for your pay stubs. I'm still seeing pay stubs that are not compliant, very often from vendors, payroll vendors. This is a very strict requirement under the labor code. Okay. All these 9 items are required to be on your payroll stub. Gross wages, total hours worked, but that's not for your salary, only for your hourly. All deductions, net wages, pay period. When does the payroll period begin? When does the payroll period end? Legal name of the employee, and either the last 4 digits of the Social Security number or the employee's ID number, one of the two. Name, address of the employer, not the DBA, not the name that people in the community know them for, the actual legal name of the employer. That is required under this statute, the actual legal name, and it has to be the full legal name. If the name of the employer ends with an Inc., then the Inc. should be included on the payroll stub. All hourly rates and hours worked for each rate. Again, this does not apply for the exempt employees. There are significant penalties that apply when an employer does not include all this information on the payroll stub. And something that I've been noticing even more lately is what kind of documentation do you, the employer, keep when you use a vendor? Okay? The law requires that the employer keep either a copy of the actual pay stub that was given to the employee or some other documentation that contains all the information that was on the pay stub. What I keep seeing is that the employers do not keep copies of the pay stub, which is fine, and they're able to print some kind of payroll registry from their system, which is fine, but they're not able to print a report that contains all the information that was on the payroll stub. As an example, recently I'm getting a case ready for trial for next month, and our client did not have copies of the pay stub. The vendor also does not keep copies of the actual pay stubs. What my client has a program that they can go in there and they can print different reports. Well, when they print a report for one of their employees, the person who's a plaintiff in this lawsuit, we got most of the information. We could see the name of the employee, we could see the employee number, we could see net wages paid, gross wages, the hourly rates, and all that. But it didn't show a payroll period. We had a pay date, but no payroll period. So that's not compliant. And of course, yeah, we can figure out the payroll period just based on the dates of the pay dates, but that's not what the law says. The law says you must keep a document that includes all the information that was given to the employee on the payroll stub. Now, thank goodness the client was able to reproduce the information, but it took doing it one payroll period at a time to print it. And the vendor was not able to help because they did not keep copies of the payroll stubs. And pretty much said, well, you can do it from the program that we offer you. You can do different reports. It may just take you longer to get the information that you need. So the reason that I'm explaining this is because I want you to make sure whatever system you have, that either you have a copy of the payroll stub or you have some document that includes all the information required under 226. Of course, since the last couple of years, you should also include on your pay stub. It's not required by Section 226, but it is required under a different law. You must provide your employee every payroll period the information about their paid sick leave, how much time they have available, and how much time they have used. So it's a lot easier generally to just include it in your payroll stuff. It can be a separate document. I have some clients that they have a payroll company that does their payroll, but they don't include the sick day on that, and they provide the employer with a separate document. That is okay. It just makes it easier to have it on the payroll stuff, the sick leave accruals. Okay, other issues for employees. Every employee must have a notice to employee form. That is Labor Code Section 2810.5. I still see some employers that do not have that form from all the employees. This is for employees who are hourly as well as employees who are salary. Every employer should have this form in their personal file. If you have hourly employees, remember that you need to pay for travel time. These are just other issues that I like to bring up. Again, the last four here on this page, they do not apply to salary employees. They only apply to hourly employees, but it's a good idea just as a reminder. If you have employees who travel during the workday, you need to pay them for their travel time. If you're rounding hours in your payroll, I highly recommend that you do not round. The law does allow for rounding, but it's very tricky, and I've seen a lot of class action for rounding. So I recommend that you do not round. Our systems are sophisticated enough nowadays that you should be able to pay employees for every single minute that they work. Off the clock work, you must not allow it. Now, of course, the problem with when somebody claims they were required to work off the clock is that there's no proof that they were required to work off the clock. So the only thing that you can do as an employer to protect yourself is to have a strong policy, a written policy that informs very clearly to the employee that off-the-clock work is not allowed. Payroll deductions, we already be very careful with payroll deductions. If you're going to deduct anything that is not your basic taxes or health benefits, make sure that you have something in writing from the employee that allows you to make deductions from their pay. The typical situation is when an employer loans money to an employee and then the employee signs some document where they agree that they will repay the loan every payroll period. That is okay. Just be careful that if the employee leaves your employment, about deducting the full balance from the final paycheck. As a general rule, that's not allowed. If there's something in writing that allows for that, it might be okay, but I can tell you that the Labor Commissioner doesn't like that, and the law doesn't like that. So it's possible to do it, but just be very careful about that. Expenses. All employees, hourly or salary employees, are entitled to be reimbursed for all expenses necessarily incurred by the employee in performing their duties. Again, this applies to both hourly and salary, meaning non-exempt and exempt employees. And this is for any expense that they may have. If they're driving their own car, then the use of their car. If they're using their cell phone for work, then they should be a reimbursement for cell phone use. They're using their personal computer or office equipment at home, then they need to be reimbursed for that. Uniforms. We do not charge employees for their uniforms. If they are required, they must be provided by the employer. Okay. Tools, same thing. There's a few exceptions for tools, but as a general rule, they either need to be provided by the employer or the employee needs to be reimbursed for the use of their own tools. So just like I've seen a lot of these issues with cell phone use, computers, laptops. So if you require them to use their own equipment, make sure that they're being reimbursed for them. Generally, the easiest way to deal with mileage is to pay the IRS rate. There's a presumption that if we pay the IRS rate as a reimbursement, they have been fully reimbursed, but it's only a presumption. That rate is supposed to cover their use of their car, the insurance, etc. Final payrolls. I always cover this because I continue to see issues with final pay. If you are going to terminate an employee, then you must pay the employee all their wages due at the time of termination. Not the next day, not 3 days later, not at the next payday, the next established payday. No, on the same day of termination. You must have a check ready for them that includes all the wages that they're due, including any accrued vacation if you offer paid vacation. No need to include sick leave. Even if the sick leave has been accrued, if it's not used, they are not entitled to sick leave. They lose it, but they do not lose vacation pay. If they have accrued it, California law considers accrued vacation as wages and must be paid. If the employee resigns, if they quit voluntarily, and they give you 72 hours notice, then you need to have their final paycheck ready on the last day of work. If they quit, but they do not give you 72 hours notice, then the final paycheck must be ready within 72 hours. Generally, you're not allowed to mail a final paycheck. You're supposed to prepare the final paycheck on the date that is due, and you have it ready for them to pick up. You let the employee know that their final paycheck is ready for pickup. And you can ask for the permission to mail it. But as a general rule, you just prepare it and you have it ready for them to pick up. If you do not comply with this final pay rules, that means that the employee will be entitled to additional penalties of pay up to 30 days. So let's say that you terminated the employee today, which is Thursday, but you did not have his check ready, and you say, come back Monday, and your check will be ready here on Monday. That means that now you're going to owe him for Friday, Saturday, and Sunday as a penalty, okay? And the penalty goes up to 30 days. And remember that you must include accrued vacation or PTO. So how do we avoid? What are some preventative solutions recommendations that we have? Key is for every employer to conduct regular audits to determine any areas of potential exposure. Since we're talking today about exempt employees, this is generally what I recommend for exempt employees if you want to do your own audit. Like I said before, you should have a job description for any exempt employee. That job description must be properly written in a way that emphasizes those duties that are of exempt nature more than the non-exempt type of duties. Review your job descriptions every year to make sure that they're still consistent with the duties being performed by the employee. Review the duties that the employee is doing. Are they still performing the same duties? Performance reviews. I highly recommend them for salary employees because that gives you an opportunity every year to reassess whether the duties have changed or not. Is this person still performing exempt duties more than 50% of the time? And then when you prepare the performance review, you want to make sure you emphasize those duties, that you're actually emphasizing that those are the duties that you are analyzing, that you're evaluating of the employee. You can even go back to the job postings. When you were looking to fill this position, is your job posting clearly indicate that there's an exempt position? And again, emphasizing those duties that are of an exempt nature. Train your supervisors. They're the ones who are there with the employee day to day, as far as making sure that those employees are they're still meeting those requirements of the exemptions. And of course, if you have any questions, consult with legal counsel. Let's go through a couple questions that I have here just to test our understanding of the subject. So let's say the first one says, store manager earns $60,000 per year, supervises, I can't see the rest of my questions here, but supervisors, one or two employees, is able to hire, fire, and exercises discretion and independent judgment in performing his job. He works 50 hours per week. 45% of his time is spent supervising and managing, and 55% of his time is spent stocking shelves and unloading delivery trucks. So as you can see, the first part of this scenario meets the requirements. He's earning $60,000, which is more than the minimum salary, supervises employees, is able to hire and fire, exercises discretion and independent judgment. Everything looks great. But the problem here is that he's only spending 45% of his time performing exempt type duties. And he's spending more than half his time stocking shelves, unloading delivery trucks, which are the non-exempt type of duties that he's required to perform. So this person is not properly classified as an exempt employee. And the employer would be liable for overtime and for not providing meal periods if the employee does not take properly compliant meal periods. Second example, executive assistant to the CEO of a large corporation earns $49,000 a year and is directly engaged in work related to the company's operations and works under general supervision. But it is a large corporation, which means that she barely missed the salary requirement. If it's a large corporation, we can assume that it has more than 26 employees, which means that the minimum salary should be $49,920 a year. That would be sufficient for this person to completely miss the exemption, and the employer will be liable for any overtime or meal period violations. In-house IT person reports directly to the CEO and earns $115,000 per year. We have no problem with the salary test here. It's way above what is required. But this is an IT person. Most likely this person is not creating programs, is not doing analysis. This person most likely is maintaining the computer system of the company, which means that based on the information in front of us, I would say that this person is not properly classified as an exempt employee. Office administrator earns a salary of $95,000 a year. He negotiates with suppliers, makes hiring decisions, and creates and implements the company's personnel policies. He also answers the phone when coverage is needed and orders lunch for the monthly staff meeting. Is this person properly an exempt employee? Get the question here, we have met the salary requirement. It appears that the type of duties that he's performing are exempt duties. The question is, how much time is he spending covering the phones and ordering lunch for the monthly meetings? If he's only spending a short amount of time, let's say 10% of his time doing those duties, then this person is properly classified as an exempt employee. So that's it for what we have today. I'll be glad to answer a few questions if anybody has any questions. Greg? Well, it doesn't appear that we have any questions. So, okay. I see one question here. Hi, will we be able to get a copy of the slides? Yes, we do post these on our website at the conclusion of the thing, and Greg already answered yes. Okay, so we have another question here. What if the employee does not want the employer to use their vacation or sick leave? Again, the employer can. If this is a properly classified salary employee, the employer has the ability to force the employee to use accrued vacation, not accrued sick leave. Sick leave is only when the person is sick or ill, but they can make them use their vacation. And remember, this is the question I'm assuming relates when somebody takes personal time off during the, that is less than a work week. Let's say they take 1 or 2 days for personal reasons, and the employer is allowed to deduct those 2 full days from their pay if it's for personal reasons, not for illness, not for disability. The employer can compel the employee to use their paid vacation or PTO. So for health issues, if the worker missed 1 week of work, employer cannot deduct. Okay, for health issues, if they missed a full work week, you might be able to deduct their pay if they already used up all their sick leave and all their vacation. But that's a little bit trickier. So you may want to give me more specifics about that. If an exempt employee has earning differentials, field, on-call, etc., if they are on leave without pay, is the employer required to pay the earning differentials? This is also very detailed. Field, on-call. I have to know more about this. But my first impression is that if they are on leave without pay, the employer does not have to pay the differentials because they're not working. That only applies when they're working. So I think that's all we have as far as questions. If you want to send me any other questions on an email, I'll be glad to send you answers. I do need to apologize to some of you who attended my last webinar. I was having some issues with my computer, and I responded to some of you with questions, and it wasn't clear to me whether they went through or not, because I had several emails that I had sent out that were on my outbox, and it wasn't clear whether they actually made it to the people that I was trying to respond to. So if you did send me a question last month or the month before that you did not receive a response, please feel free to send it to me again. My system has been fixed, and I should be able to respond to all your questions without any problems.
Roxanne, I'd like to just interject that we do have more questions, but we had a little technical glitch there where my vocals went away and couldn't get it back. So Roxana was reading the questions that I rapidly printed out for her. So we will get back to you with the other questions that did come through. Just as a general note, several of you were asking if they can get copies of this webinar. Answer is yes. It'll be on the website on Monday. Look under our webinar tab, and also the PowerPoint is available under our workshop tab. So we will look forward to getting back to you with these answers. And thank you again for joining us today. We sure appreciate it.
Thank you.